So time to time it remains controversial, and it's basic, no need to, I guess, in in public ad we don't respect it. Still we are trying to teach for, since it remains in So the Constitution talks about this. You read the Constitution, that 102 and 191 about any MP, MLA, so holding office of profit stands disqualified, but it does not define what is office of profit. Although it says also that merely holding a government office is not office of profit. A law was brought not to define what is office of profit, but rather to protect MPs from disqualification. So the law is known as the Prevention of Disqualification Act. And in this law, it is in this law that simply one office is mentioned. So what they will do is that they will amend this and they will say that this office is not office of profit. Again they will amend and they will say this office is not office of profit. So if let's say that any institution is mentioned, let's say that X institution is mentioned that it is not office of profit, and then anyone holds that position, so that person, that MP will not be disqualified. But suppose that they forget to mention somehow Y office as office of profit, बाद में उनको याद आया कि अरे ये तो office of profit है, so then let's say that it becomes controversial. And then they try to deal by retrospective effect. They will bring retrospective effect of this, which is struck by court. That is how the controversy, one aspect of controversy. So this is a flaw in lawmaking, that if you remember Parliament you told you have leader of opposition but you have not defined it, you have office of profit but you have not defined it. So it is a legal flaw, lawmaking flaw. And why they do not want to define it? Because they want to take the benefit of that. Right. Leave it to court, देखा जाएगा जब कोर्ट में जाएगा तो. So when you do not define, so you leave it to court to define, leave it court to decide. And then that is how, let's say that they will simply mention in that, and therefore court, कभी टाइम ऐसा आया होगा तो कोर्ट ने बोला ठीक है, we will define it. Right. So Supreme Court defined in 1964. In its one such judgment, it gave definition of this office of profit. That it should be government office or created by government, government is the appointing authority, government is the appointing authority. That government can terminate also. Simply that 4 or 5 points cannot be written. Simply it can be that it's government office, remunerative, influence. That's all. So office of profit applies to government offices, not private offices or non-profit offices. This is first. Second thing is that sorry, just coming back. So the office, let's say it should be government office, remunerative, you derive remuneration on that behalf. And because of holding that office, you have influence on that office decision making. These are the three criteria. Now then, the rationale is why office of profit, means why MP, MLAs, they cannot hold other government offices. Right. No. So, do you have any idea why they cannot hold a government office? Concept of separation of powers between legislature and the executive. So, it is the concept of separation of powers between, it is most important point, first point. There is separation of power. So, it means when MPs, MLAs join executive position, so it is breach of separation. Then next is conflict of interest. Next is conflict of interest. That they would not be able to discharge they would not be able to discharge their role, their duty as lawmaker independently. Without external influence. Without external influence. Yes. Violation of 91st Amendment Act. '91st Amendment Act, which says that COM strength cannot be 15% for let's say that union government, for states, let's say for Delhi it is 10%, means for states 10%. As parliamentary secretaries, when they appoint, parliamentary secretaries are considered part of Council of Ministers. They are part of Council of Ministers. Other points you can write as per your choice, but these are the some relevant points. Political corruption, give and take, accommodation, right? All sort of things happen. Hence, ultimately, it affects legitimacy of democracy. Legitimacy of democracy. So it is clear, I guess, nothing very complex. Now,
third point, can you explain the third point? That states wala is specific for Delhi or for all the states?
Delhi, they have fixed the number also. It is 10% for states.
So it's, I think it's 15% for the state also.
Maybe. So, and 10% for Delhi. This.
So in Delhi it's 10%. Delhi for 10% and all the states for 15%.
Yes, it can be, let's say. So, for Delhi, 10%. And yes, so you were asking, it was this question.
Sir, how this official profit violates 91st Amendment Act?
Parliamentary secretaries, when they are appointed, so they are considered as minister. They get the status of a minister. Many a time they get the status of, at the state level, they give cabinet rank minister status. Therefore, अगर आपको prelims question में आएगा तो parliamentary secretaries are part of Council of Ministers. It is very clear. It was an expected question in past, but now it is not. It has been mentioned by R.K. Arora also. It has been recognized by the high courts also. This parliamentary secretaries are part of Council of Ministers. And high courts have also recognized. R.K. Arora also considers that they are part of Council of Ministers. Remember that day we told about composition of Council of Ministers. So we mentioned about this. So, since they are part of Council of Ministers and 20 MLAs are appointed as parliamentary secretary in Delhi, so don't you think that it will go more than 10%? Not only in Delhi, we'll mention that other states. Isn't it violation of this 91st Amendment Act?
Yes, sir.
Now, the controversies. So, first is that at union level, in past, at state level, since states appoint parliamentary secretaries, Punjab, West Bengal, Nagaland, Goa, Maharashtra, etc. Like you can write.
Sir, it would be parliamentary secretary in state level also, or
Yes,
some other terminology.
it's same now. In 2015, in 2016, 2015, 26 legislators were appointed parliamentary secretaries in Nagaland. When 60 MLAs joined ruling alliance, 60 MLAs joined ruling alliance. Goa exempted more than 50 offices by means of an ordinance. Puducherry exempted more than 60 offices by passing a bill in 2009. Delhi, 21 parliamentary secretaries were added to the 7 ministerial posts, which constitute 40% of 70-member legislature. Therefore, at a state level, there have been practices of accommodations in the name of parliamentary secretaries. Even if the various high courts have struck such practices, like Calcutta High Court in 2015, stated that the parliamentary secretary was an attempt by state government. Parliamentary secretary's appointment was an attempt by the state government to bypass the constitutional ceiling constitutional ceiling on the number of ministers. Next, Bombay High Court in 2009 held that appointing parliamentary secretaries of the rank and status of a cabinet minister is in violation of Article 164 1A capital 1A, which is related to fixing the strength of Council of Ministers, to 15%. Therefore, at a state level, even if high courts have stricken the acts of accommodation of parliamentary secretaries, still the practice continues. At union level, we'll come to union level. In case of Delhi, and city Delhi, 21 MLA, they were appointed as parliamentary secretary. But law was amended later. Means बाद में याद आया था. Law was amended later, and retrospectively the office was created, and the offices were retrospectively created. It was challenged by the opposition party. Before Election Commission. The Election Commission took a decision for disqualification and advised to President. President acted as per the advice of Election Commission and disqualified the MLAs. They challenged in the Delhi High Court. The High Court quashed the stand of Election Commission. On the ground that there was violation of natural justice. That is, the High Court did not completely question the stand of Election Commission. Rather, the MLAs not given chances to defend themselves. Hence, the Election Commission can review its decision. The case was pending for further hearing. By the time election came, and the case became infructuous. infructus, infructuous. INFRUCTOUS. ऐसे केस होता है. So it means ultimately the main question of whether appointing parliamentary secretary amounts to office of profit has not been scrutinized. So now Delhi government was saying that, means that time they say that they are not deriving any remuneration. Office does not derive any remuneration. Office is not given any privilege, etc. This is how. So they were defending, but that is how it happens that the courts have also not completely considered whether appointing as parliamentary secretary itself amounts to violation of office of profit. Rather, they are more concerned about process, procedure, how you have disqualified, and then the matter remains, the core matter remains as it is. Means the core matter remains what exactly, because when they create parliamentary secretary, so they have the rules, business rules of the government, under which they will try to manipulate. They will try to manipulate in such a way that it will not be considered as office of profit. So this is how it happens. And the controversy, so the controversy has not ended. It will again come case by case, and the courts will take their stand. This is what we can say. Means just imagine, the matter has not been heard whether it parliamentary secretary appointment by Delhi government is lawful or unlawful. Rather, they decided the process. Process means election commission did not give them opportunity to defend, so you give them opportunity to defend and then decide. And then election commission does not decide. It became 4 years. No anything. No, nothing is done. And the case kept pending, means further hearing, and then after, what you will do when election is announced? New election comes, so what you will do after that case? It becomes infructuous. Hearing this case or not case, it hardly matters.
Means sir, case has not been taken again.
Yes, case has not been taken again.
Yet.
Yes. It was 2018, March 2018. Thereafter, election was held in Delhi when? 2019?
20.
So 2020 election was held, and that is how we'll find that. So 2 years happened, 3 years happened, no any hearing. No, it's not what SC. They cannot themselves hear the case unless the party goes.
But sir, they have the power of so more too, na?
No. That power they do not exercise. Very rarely they will exercise. Otherwise, then it is. Unless the party goes again, let's say, unless election commission takes it, election commission does not review the decision. Basically, it was that election commission should reconsider and election commission should give them chance to defend. The election commission does not reconsider. So what the court will do now? The matter remains like that. Now, let's take very interesting case at center level. What happens? So, one is Pranav Mukherjee. When he was elected as president, and he was, let's say that he took oath as president. After taking oath as president, he came to realize कि he had not resigned some of the office he was holding. They hold many positions, na? Honorary positions, that is how you can say. And that amounted to office of profit. So his election was challenged in the court, Supreme Court. His election should be quashed because he was holding office of profit. But court ने यहाँ पे lenient view लिया, lenient की ठीक है जाने दो, भूल गए होंगे, resign कर देंगे. Right. So then he resigned. Means it is mentioned they should not hold any government office. Right. This, if you read the qualification, so they should not hold any office of profit. And after taking oath, then he came to know that he had not resigned some of the offices he held. So that is another controversy you will find that. But here, let's say court took a lenient view and let's say that he left it. Let's take interesting story. It is related to Jaya Bachchan and Sonia Gandhi. So Jaya Bachchan was head of director of Uttar Pradesh Film Development Council when there was Samajwadi Party government. She is Rajya Sabha member also from Samajwadi Party. So she was holding this director of honorary. So she was director of Uttar Pradesh Film Development Council. So कांग्रेस पार्टी को कहीं से पता चला होगा. So it came to know that Uttar Pradesh Film Development Council has not been mentioned in Uttar Pradesh Prevention of Disqualification Act as office of profit. It is not office of profit. So since it was not mentioned in Uttar Pradesh law that it is not office of profit, it means it is an office of profit. And therefore she was told that you are holding office of profit and you have to resign. She had to resign. Right. So she resigned. It is the time when UPA government was in power. APJ Abdul Kalam was president. So she resigned. Interestingly, other states including Madhya Pradesh, means comparative studies done that time, other states including Madhya Pradesh, they had their film development council and it is mentioned in the Prevention of Disqualification Act, it is not office of profit. But in Uttar Pradesh it was not mentioned that it is not office of profit. And then she had to resign. So she resigned, again elected, that's different thing. Meanwhile, pata chala ki Sonia Gandhi was also holding office of profit. Means she was head of what you can say National Advisory Council. National Advisory Council was created and she was chairperson of National Advisory Council. And when they created, they had not mentioned in the Parliament Prevention of Disqualification Act that it is not office of profit. So what happened? She had to also resign. And again she was re-elected from the same constituency. Now, right, they amended, that is how Office of Profit Bill. Office of Profit Amendments, that is Parliament Prevention of Disqualification Amendment Bill was introduced, and she is got elected. It was sent for President to give assent, President sent for reconsideration. By saying that such bills should be comprehensively, means you define what is Office of Profit, means it should be comprehensive. So they simply mentioned that National Advisory Council is not an Office of Profit. Now she is again, let's say, appointed as chairperson of this. Bill is not yet approved. They feared that she will be disqualified. The President is not giving sanction. That is how sarcastically it is said that किसी पार्टी में मनमोहन सिंह ने बोला था कलाम साहब को कि साइन कर दो नहीं तो सोनिया गांधी का. Anyhow, so what you come to know by this?
Sir, office is designated as an Office of Profit according to their will.
Yes.
It's a patchwork type offer, not.
Yes, so basic rationale is not getting addressed, rather only a legal formality is done. That is how you should know that.
They don't have to give reasons why they something is mentioned in the not Office of Profit.
बिल्कुल नहीं. Simply they mention that कि National Advisory Council is not an Office of Profit.
There is no one to ask.
कौन पूछेगा? It is brazenly, let's say that, कि shameless creature many a time, but I don't want to sound like this in early morning. Anyhow, so the question is that that's why you know that they have not done their duty. They should do their duty properly. They can be good person, bad person, that's different thing, but then this is called law making. You should make things clear, right? Now the basic rationale that we have written, is this: separation of power, conflict of interest, violation of this. Do we take into consideration this? Even if they are, let's say, violated, the most aspect is this, the accommodation. Why that number of MLA should support? You know that all MLA supported the government in Nagaland. So other some MLA, when you are creating that post, you are, let's say, accommodating. Basically it happens in smaller states. In smaller states, accommodation is easier than the bigger states. So small states are subject to different types of problems. Bigger states are subject to different types of problems. When we were teaching president rule, let me tell that bigger states are less prone to president rule. Smaller states are more prone to president's rule. Because bigger states में क्या होगा, या तो government, let's say government will fall, or there will be a majority government. So if you take Rajasthan, Madhya Pradesh, if you take Uttar Pradesh, Maharashtra, so they have less number of presidents rule. But if you say smaller states, the research says smaller states are more prone to president's rule. Similarly, smaller states, they are more prone to defection. Because small parties, small number of seats means less number of seats, and then there can be more chances of defection. So there are chances of accommodation. The main problem is not, let's say, that ye to theek hai, that is more theoretical. This is how, let's say, accommodation, political corruption, and this is how it will happen. And that's why the focus should be to avoid all these things and maintain separation of power, avoid conflict of interest. Now you should know that case, since it has not been defined, try to understand that separation of powers. If you take other countries means ki Western countries, in UK, whenever any institution is created, so then it has to be mentioned whether it is an office of profit or not. Means it is their law making system that whenever they will create, like say National Advisory Council is created, so then they will have to mention whether it is an office of profit or not. This, so then at the very beginning itself the problem is addressed. When you create any office, so you have to mention whether it is office of profit or not. Second thing is that they have to make their credentials, means they have to give the details of their, let's say, associations. We cannot do that kind of things in our country. Each and every MP in the parliament, so that person details which organization he is associated. That is, they have to give clarity on their conflict of interest. Right. This. We have not reached to that level where we can see when any particular bill is getting passed, so then the parliamentarians' conflict of interest is also analyzed. Whether, let's say, suppose you are passing Companies Act, or you are passing any such, let's say, bill related, so whether any member of parliament or some member of parliaments are linked to companies, and if they are linked, so in which capacity? So they have to make, means they have to give details of their association. When you become MP, then you have to give details of your association, which organization you are associated. Okay. And lawyers in the parliament, so they will have to give details which party the person is a client. To make the things clear, to avoid conflict of interest. That level of debate has happened in our country also, but it has remained at debate level. That is called the bigger aspect of conflict of interest. So we are not able to fulfill this level of conflict of interest, to forget about the bigger level of conflict of interest and why it should be only applicable to public office. When there is a more and more dependence on private, everything is becoming private and non-state type. In that situation, even holding a private office will also result into conflict of interest, because the law making is related to also other sections, other departments. So this has also been questioned, should we have only public office, or we should also include other offices also. Like you can see that how they hold position in cricket, how politicians have dominated in the field of cricket. And can you see they have got the position because they have the qualification, or because they are the politician member of parliament?
सर तभी तो बीसीसीआई को टैक्स में देना पड़ता है.
This you have to understand. So sports bodies, they are non-profit bodies, but they are led by politicians who never played the sport. So there are some bigger issues, but we'll finish confined. Let's say, means what we can say is that in the end, the office of profit needs a comprehensive review, so that there can be justice. Justice. मैं तो उसको I always see his face कि क्या सोचता होगा, right? Whether then I see the face of Rahul Sir Saurav Ganguly कि when both are sitting together, तो वो what he may be thinking, right? This anyhow. So it's not qualification, and that is how you know it very clear that why he has been appointed and how he has been appointed. The good thing is that all the three persons are young persons, right? But bad thing is that Rahul Saurav Ganguly comes under huge pressure that he got even heart attack, right? this, sorry to say that. बेसिकली उसको बोला गया था सौरव गांगुली को बंगाल इलेक्शन में कि बीजेपी से खड़ा हो जाओ, फिर उसको हार्ट अटैक हो गया. Because he could not go through, he is good, he is a different person, and he did not want to go through the way Mithun Chakravarti went. Right. Anyhow, these are all politics. Let's summarize this, finish this. Therefore, the controversies at a state level, and the issue of Jaya Bachchan and Sonia Gandhi related to disqualification at center, so that the Office of Profit Law lacks comprehensiveness that it fulfills merely legal requirement. It fulfills merely legal requirement rather than the substantial rationale behind Office of Profit of protecting separation of powers, avoiding conflict of interest, and as a lawmaker playing important role in legislature without any external influence. But when MPs and MLAs are accommodated by the government by taking the benefits of legal loopholes, in ultimate sense, it also affects quality of debate and discussion and functioning of legislatures. Change paragraph. Unlike practices in Western democracies, like UK, wherein first, whenever any law is made and an institution is created, it is mentioned in the law whether the office is office of profit. Second, office is office of profit. Second, the legislators have to give details of their associations and practices outside legislature, be it related to public, private, including lawyers and their association with their clients. so that in lawmaking, the conflict of interest is avoided. Conflict of interest is avoided. Change paragraph. In India, the Office of Profit Law should also be comprehensively reviewed to focus on protecting the three basic rationales. Three basic rationales, and discouraging any such act of political accommodation rather than merely avoiding disqualification by mentioning in law that this office is not office of profit. And then manipulating the legal provisions to avoid disqualification, which gives scope for judiciary to intervene. So that is what we can tell about Office of Profit. So we'll take next call, simultaneous holding of elections.